Matthew Spaulding, Associate Vice President and Dean of Educational Programs for Hillsdale College in Washington, D.C. Welcome to the Kirby Center for Constitutional Studies and Citizenship. A long-time centerpiece of our work, the name of the center, and of Hillsdale College is the center around the principles of the Declaration of Independence and the Constitution. Liberty and equality, the consent of the governed, the meaning of the first document, working its way out through the rule of law, the second document, especially in its words and structure, the idea of separating out the legislative power from the executive power and the judiciary from both. We have also focused much of our work on the debate over those precise things stemming from the progressive movement, about new ideas of how to organize our structure, to talk about our principles, new ideas of governance, what they call the administrative state. This new form has played out over the course of the 20th century and is increasingly dominant in the current debate. The question being addressed by our speaker today is this new form, which it really is, a new method, a new form, is it itself lawful, or is it merely necessitated by modern society? In a new forthcoming book, published by the University of Chicago Press, due out any day now, Philip Hamburger has taken a long view, an older and historical view of this precise question. And he argues that what we face today, this idea of administration, of government rule by regulators, had its origin long ago, and that the resistance to that same thing gave rise to another thing, constitutionalism, which is to say that this is an older and more profound question than merely the latest regulatory move of modern government. Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. He writes very widely on constitutional law and its history, and in 2002 wrote another wonderful book on the legal history of the separation of church and state for Harvard University Press. Previously, he taught at the University of Connecticut Law School, at George Washington University Law School, and the University of Chicago Law School. I'm very pleased to have Professor Hamburger with us here today, and I look forward to this talk and his important scholarship, which is coming out soon. Please join me in welcoming him. Thank you.
So, is administrative law unlawful? There are many complaints about administrative law, that it is arbitrary, that it is a burden on the economy, that it is an intrusion on freedom. The question addressed by my book and by this talk is different. The question is administrative law unlawful? Although others have addressed this question in terms of doctrine, my focus is going to be on constitutional history. Those who forget history are doomed to repeat it, and I suppose those of us who don't forget it are doomed to watch others forget it and suffer under the consequences. And this is what has happened under administrative power. Administrative law is commonly defended as new, a new sort of power, a product of the 19th and the 20th centuries, modern power that developed to deal with the problems of modern society and all of its complexity. It thus allegedly could not have been anticipated by the Constitution, and so was not barred by it. My thesis, in contrast, is that administrative power is actually very, very old. It revives what used to be called prerogative or absolute power, and it thus is exactly what the Constitution developed in order to prohibit. Constitutional law developed in order to prohibit absolute power. But we as a nation have forgotten this, and we therefore now suffer under a new bureaucratized version of absolute power. Before beginning, I want to say just a little about historical method. Not the most interesting topic, I know, but it's worth mentioning. First, my focus is not original intent. Instead, the goal is to recognize the original danger, the danger that constitutional law sought to prevent. So rather than focus on original intent, my focus will be on something like a constitutional version of original sin. Second, although the method is historical, the goal is conceptual. One doesn't have to leave with a lot of facts. What one should leave with are a few simple concepts, because I think the history reveals a reconceptualization of administrative law. And so by looking back at the past, we should be able better to deal with the present and the future. To understand what is at stake, I want to begin by explaining what I mean by administrative law. There are many possible definitions, and the one that matters here is historical. Put simply, administrative acts are binding or constraining edicts that come not through law, but through other mechanisms, through other pathways. For example, when an agency issues a rule constraining Americans, barring some sort of pollution or land use, this is an attempt to exercise binding legislative power, not through an act of Congress, but through other sorts of edicts, an administrative edict. Similarly, when an agency adjudicates an administrative violation, imposing a fine or some other penalty, this is an attempt to exercise binding judicial power, not through a judicial act, but again through an administrative act. Now, leave aside for a moment whether or not these administrative edicts are unlawful. What makes them administrative is that they bind Americans not through law, nor through the decisions of a court of law, but through other mechanisms. So you can think of administrative law as a form of off-road driving, right? The Constitution generally offers two avenues of binding power: acts of Congress and acts of the courts, judicial acts and statutes. But the executive prefers to drive off-road, not through statutes, not through judicial acts, but along other administrative pathways. And for those in the driver's seat, this can be quite exhilarating. Of course, for the rest of us, it's just a little unnerving. This understanding of administrative power in terms of binding edicts excludes, of course, much executive action. So when I complain about administrative law, my complaint is not about government benefits or privileges. It's not about welfare or Social Security. And my complaint is not about orders to officers within their constitutional authority as executive officers, for example, in distributing welfare. Instead, the problem consists of attempts to bind or constrain Americans, legislatively or judicially, through acts other than acts of Congress and acts of courts. But on this understanding of administrative power, of course, administrative law is a constitutional puzzle. Our government is full of puzzles, but none are more serious than administrative power. The immediate problem is that administrative power does not match the powers authorized by the Constitution. The Constitution authorizes three types of power, right? Legislative power in Congress, executive power in the president and his subordinates, and judicial power in the courts. But what then is administrative power? A fourth type of power? It's been suggested as much by many of its advocates. But then how is it constitutional? My talk today will lay out two possible answers, and both are framed in terms of history. The first and conventional answer to the constitutional question comes in a conventional or sunny vision of the history. This conventional vision emphasizes the modernity of administrative law. There are many doctrinal justifications for administrative law, and we can talk about them later if you want. But the foundational justification is that administrative law is modern or novel, and thus without much serious history. From this perspective, administrative power begins in 1887 when Congress creates the Interstate Commerce Commission. And administrative power then just repeatedly expands every several decades in response, it's said, to American society in the early 1900s, 1930s, 1970s, and even more in the last several years. A variant of this account, this sunny, rosy view, comes from Jerry Mashaw, who suggests that administrative law actually is a little bit older, that it began to develop in the early practices of the federal government. But even that account of administrative law maintains the gist of the standard version. The standard history, whether it begins in the 1790s or in the 1880s, is that this is a post-1789 development, a pragmatic response to practical problems of American life. Although it's not mentioned in the Constitution, this sort of law allegedly is in indigenous and empirical growth, which necessarily arose to deal with the pragmatic realities, again, of American life. It's almost a theological mantra. Well, the conventional vision obviously turns out to be, in this form, very much an apology for administrative power. Sociologically, the message is it's about modernity and necessity. Administrative law is a modern type of power necessary to handle complexities of our lives. It thus is anti-modern and quixotic to resist this power. I guess I'm anti-modern and quixotic, but you may have guessed that. Constitutionally, the message is that administrative law developed after the adoption of the Constitution. Administrative power, thus, allegedly, could not have been anticipated by the Constitution, and therefore, even if it's not amongst the Constitution's powers, it's a necessary and modern addition. It's a very reassuring story, if you believe it. The justificatory implications are powerful. In the conventional vision of the history, post-constitutional necessities slice through the tripartite divisions of power in the government and justify an entirely new approach. In the standard vision, it's a pragmatic necessity for the executive to exercise not only executive power, but also legislative and judicial power, all three in one branch. You know, look, Ma, no hands. I can do it all in one. It's in the standard vision, it's a pragmatic necessity to adjudicate disputes without judges and juries. If an agency can even be a prosecutor, judge, and jury. In the standard vision, it's a pragmatic necessity for the due process of law and indeed all procedural rights to be put aside when you adjudicate in the executive branch. This is, they say, all the process that is due. And in the standard vision, it's a pragmatic necessity for judges to defer, not exercise independent judgment, but defer to executive interpretations of law, and so forth. You know the rest. But there are problems with this conventional history and its justifications. And the most basic question concerns historical accuracy. Is it true that administrative law is a modern, post-constitutional American development? Is it true that the Constitution could not have anticipated administrative law and did not prohibit it? Ultimately, this conventional history I propose does not dig deep enough. It is a cheerful, breezy vision of history in which the past is not examined too lightly and all is sweetness and light. So let's turn to a second vision, a much darker vision, which looks below the surface of the usual apologetics and sees a very dim and dismal past. In fact, administrative power revives absolute power. Rather than a modern necessity, it is a version of a recurring threat, one inherent in human nature and the temptations of power. The constitutional history of the past 1,000 years, in common law countries at least, records the repeated ebb and flow of absolutism on the one side and law on the other. There always have been pressures for absolutism, and law only sometimes has been able to resist. During the next 10 minutes or so, we will examine the history of absolute power. And as I recount it, please think about the modern parallels. I may be talking about medieval or 17th century kings, but you should be thinking ahead of me about contemporary presidents, and not just the current president, the last century of presidents. We need to begin with prerogative power. English kings were widely expected to rule through law. They had parliament for making law and courts of law for adjudicating cases, and kings were expected to govern through the acts of these bodies. Thus, to bind their subjects in general, they needed to seek acts of parliament, and to bind their subjects in particular cases, they needed to go to the courts for acts of the courts. But kings were discontent with governing through the law. They wanted more than they could get when going to the legislatures and courts. And they often acted on their own, not through law, but through royal or prerogative power. The power ordinarily exercised through law thus was evaded when kings acted through prerogative power. Prerogative power thus was the predecessor of administrative power. Prerogative power was the personal power of kings. Administrative power is the bureaucratized power of states. But otherwise, they are similar. They both have been evasions of law. Consider these prerogative evasions, and they should sound familiar if you have any experience with administrative law. Ordinarily, kings bound their subjects through statutes, but through their prerogative power, they bind subjects through proclamations or decrees, what we call rules or regulations. Ordinarily, kings repeal old statutes by obtaining new statutes, but through their prerogative power, they issued prerogative dispensations and suspensions, what we call waivers, right? Ordinarily, kings could enforce the law only through the courts of law, but with a prerogative power, they enforce their extra-legal commands in their own prerogative or extra-legal courts, notably the King's Council, the Star Chamber, and the High Commission. where the due process of law gave way to inquisitorial process derived from the civil law, what we call administrative process. Ordinarily, judges resolve disputes about royal power in accord with the law and their own independent judgment. But on account of the prerogative power, kings expected deference from judges. They expected deference to prerogative regulations, to prerogative interpretations of statutes, what we call the Chevron problem, and deference to prerogative fact-finding, the administrative record. Interestingly, though, 17th century judges refused to defer on the whole. Something has changed. Last but not least, prerogative power evaded English divisions of power. They did not yet have a full separation of powers, but they did have a basic division of powers. Parliament had power to make laws, the law courts had the power to adjudicate, and the king had the power to exercise force. It isn't that different from what we're familiar with. Nonetheless, when kings acted through their prerogative power, they, or their prerogative courts, what we call their administrative agencies, exercised all government powers in one. For example, the Star Chamber could make regulations, prosecute infractions, and adjudicate them, all in one agency. Evidently, prerogative power was a means of evading government through law. And just as kings evaded law with prerogative power, the executive now evades law with administrative power. The defenders of this sort of prerogative or administrative power described it as absolute power. This is not an accusation. This was their defense. This was their justification. They were proud of it. Of course, the phrase absolute power can have many meanings, but it once was used in very concrete ways to describe the prerogative or administrative power that evaded the law. Precisely what made this power absolute? Here we get to the conceptual payoff. Conceptually, there were three central elements of absolute power. Absolute power was extralegal, supralegal, and consolidated. First, absolute power was extralegal. It was extralegal in the sense that it bound the public not through law, but through other sorts of edicts. For example, when kings bound their subjects not through statutes, but through prerogative decrees, rules, regulations, they acted extralegally, not through law, but through another means. When kings made adjudications binding their subjects, not through the acts of the law courts, but through prerogative adjudications, they acted, again, extralegally. Thus, the first way in which prerogative, or today administrative power, was absolute is that it was an extralegal power, exercised not through law, but outside it. The second absolute element of power was that it was supralegal. It was supralegal, and by the way, these terms turn up amongst medieval philosophers. I'm not inventing these terms. These were the terms they used. It was supralegal in the sense that kings expected judges to defer to it. Judges had a duty to exercise their own independent judgment in accord with the law of the land. They could not defer to others. Parliament even passed statutes requiring them to take oaths not to defer to the king or the king's letters. This was a strict requirement already in the 14th century. Kings, therefore, could not impose extralegal power unless they could evade review in the courts. And kings, therefore, insisted that much of their prerogative was above the law, that it was supralegal. And from this perspective, because it was above the law, judges, they said, had to defer to the prerogative decrees, the prerogative interpretations of statutes, and prerogative adjudications. Deference to prerogative or administrative power thus depended on this power being supralegal. And this is the second way in which it was absolute. Again, it sounds familiar, doesn't it? Third, absolute power was consolidated. It was consolidated in the sense that it united all government powers in the king or in his prerogative courts, again, what we call administrative agencies. When prerogative or administrative bodies made law, adjudicated, and executed it, they obviously were combining all powers of government in one. Prerogative or administrative power thus could be absolute in three basic ways: extralegal, supralegal, and consolidated. Underlying these three elements was the usual conceptual justification for absolute power: necessity. Necessity, it was said, has no law. It thus stood apart from the law, and it rose above it. It therefore was the repeated justification for extralegal, supralegal, and consolidated power. So whereas common lawyers rested on the law of the land, the king attempted to evade and defeat claims of law with claims of necessity. Let's look at some historical examples. Much of the history of the common law can be understood as repeated responses to absolutism. When King John calls Englishmen to account extra-legally in his council, not through the courts, but just in front of him and his bureaucrats, the barons in Magna Carta in 1215 demand that no freeman shall be taken or imprisoned or seized, nor will the king send for him, you can't even send a summons, except by the lawful judgment of his peers or by the law of the land. When 14th century English kings questioned Englishmen in the King's Council, Parliament in 1354 and 1368 enacts the first due process statutes, requiring the king to act through the due process of law. This is, again, the same issue we face today. When 14th century kings, when James I attempts to make law extra-legally through proclamations, it's the early 17th century, the judges respond in 1610 with an opinion that binding proclamations, executive acts that attempt to bind people like a statute, were unlawful and void. When James demands judicial deference to prerogative interpretations of statutes, it's one of his pet concerns. He wants what we call Chevron deference. The judges refuse. They don't go along with it. Indeed, in 1641, Parliament abolishes the prerogative courts, the Star Chamber and the High Commission, which are the bodies that engage in extra-legal lawmaking and adjudication. And most profoundly, the English defeat absolute prerogative power by developing ideas of constitutional law. The English Constitution, of course, was lost in the mists of time, if it ever really existed, but it was said to be the source of all government power, and it was said to place legislative power in the legislature and judicial power in the courts. The Constitution, therefore, made clear that there was no extra-legal, super-legal, or consolidated power. And the US Constitution echoes all of this. It echoes this response to absolutism. Early Americans were very familiar with absolute power. They feared this extra-legal, super-legal, and consolidated power because they knew from history it could evade all law and all legal rights. And it therefore is no surprise that they framed the Constitution to bar this sort of power. To be precise, Americans established the Constitution as the source of all government power, and they used the Constitution to place legislative power in the legislature and judicial power in the courts. There thus could be no extra-legal, super-legal, or consolidated power. Well, but that's changed. Nonetheless, absolute power has come back to life in common law lands. After absolute power was killed off in England and America, it circled back, oddly enough, from the continent, through Germany and especially Prussia. Although extra-legal power was defeated in England and America, it survived and flourished in civil law countries, most prominently in France and Germany. There, what once was the personal prerogative power of kings became the bureaucratic administrative power of the states. And the Prussians were the leader of this development in the 17th and 18th centuries. And in the 19th century, they become the primary theorists of administrative power. And they celebrated, they didn't hide, they celebrated its absolutism, and they celebrated its defeat of constitutional law and constitutional rights, which they mocked. And strangely, this was the source of American administrative law. Thousands upon thousands of Americans studied administrative power in Germany. You couldn't get a job. I teach at Columbia University. You could not get a job teaching political theory in Columbia unless you had studied German administrative power. You had to actually go to Germany, and most actually had German degrees. Now, this studying of German law was not enough to revive absolutism, but at the same time, progressives were becoming increasingly discontent with elected legislatures and independent courts. This, in fact, was probably not a political matter, but a class matter, but that's another matter you can read in my book if you're interested. Progressives increasingly sought to evade rule through and under law, and they therefore embraced German theories of administrative power. They adopted absolutist theories of extra-legal lawmaking and adjudication, absolutist theories of deference to superlegal power, including interpretation, and absolutist theories about consolidated state power. And they justified all of this by insisting that necessity defeats law, especially constitutional law. The progressives, moreover, understood what they were doing. This wasn't a hidden agenda. They taught this in our finest universities. And as late as 1927, after many of them had begun to go quiet on the subject when they realized it was politically unpalatable, even John Dickinson writes in 1927, the question of whether or not the king can issue ordinances parallels our modern question as to whether or not an executive body or officer can establish regulations. And the arguments pro and con have followed much the same lines. Again, he knew exactly what he was doing. There thus is a direct intellectual connection between medieval absolute power and modern administrative power. It's not merely a revival, it's the same thing, the same intellectual tradition which circled back from the continent. So what the English defeated in the 17th century and what Americans rejected in the 18th century, Europeans and especially the Prussians preserved and developed, and from there Americans reintroduce it back into America. Absolute power thus has been continuous, and although it once was defeated by constitutional law, it has come back and triumphed. Over the past 120 years, Americans have reestablished the very sort of power that the U.S. Constitution most centrally forbade. Administrative law, I'm repeating myself perhaps, but it's worth driving home. Administrative law is extra-legal in that it binds Americans not through law, but through other mechanisms, not through statutes, but through regulations, not through decisions of courts, but through other adjudications. It is superlegal in that it requires judges to put aside their independent judgment, their very office of being a judge, and defer to administrative power, once again bowing to it as if it were above the law. And it is consolidated in that it combines the three powers of government and administrative agencies. Absolutism has returned. This dark vision of history has powerful constitutional implications. In general, the history shows that the Constitution barred this extra-legal, superlegal, and consolidated power. Regardless of whether you call it prerogative or administrative, this is what the Constitution most centrally forbade. But the history is also power when we get into specifics. And I therefore want to close this talk with some examples of how the history sort of darkly illuminates some familiar constitutional problems. There are many possible examples, and you can read about them in my book because I think they'd be useful in litigation, amongst other things. But it should suffice to discuss two of them, delegation and procedural rights. One standard defense of administrative power is delegation. For example, it is said that Congress delegates its lawmaking power to administrative agencies, and they then use this power to promulgate regulations. From this perspective, it does not matter that the regulations are extra-legal because Congress has delegated its lawmaking power. But this is a very poor defense. In the past, the delegation of lawmaking was actually a familiar feature of absolute power. This is not something newfangled that solves the problem. When kings exercised extra-legal power, they usually had at least some delegated authority from Parliament, or at least an ambiguity they could run with. For example, Henry VIII issues binding proclamations under a statute he obtains called the Act of Proclamations, which authorizes him to do this. Yet even with legislative delegation, his binding proclamations were understood to be exercises of absolute power. And in centuries later, particularly the 18th century, the Act of Proclamations is condemned as unconstitutional. David Hume, no Whig, says this: when Parliament gave to the King's proclamation the same force as a statute enacted by Parliament, it made by one act a total subversion of the English Constitution. The delegation of legislative power thus was a familiar aspect of absolute power. How does the Constitution respond? It expressly bars the delegation of legislative power. I know that may seem odd to those of you who may have studied this. It's widely said, for example, by Cass Sunstein, that the Constitution does not expressly bar the delegation of legislative power. But read the Constitution, indeed the first words. The Constitution's very first substantive words are, all legislative power herein granted should be vested in Congress. The very first word, all, precluded delegation. You see, if all legislative powers are in Congress, none of them can be elsewhere. It's not an accident that the word all was put there. It was put there precisely to bar delegation. Evidently, the delegation of legislative powers was a familiar problem, the most serious of problems, and the Constitution responded by expressly barring it. There's a lot more that we can say about delegation, but let's leave that aside and move on to one other example. A second constitutional problem illuminated by this dark vision of history is the administrative denial of procedural rights. Administrative adjudication evades almost all of the Constitution's procedural rights. It offers some minimal protections, but even in cases that are criminal in nature, it subjects Americans to adjudication without real judges, without juries, without grand juries, without full protection against self-incrimination, and without other due process of law and so forth. You can just run through the Bill of Rights. Indeed, like the old prerogative courts, administrative courts substitute inquisitorial process for the due process of law. And by the way, that's not just a vapid, general, abstract accusation about inquisitorial process. It's exactly what a lot of early administrative law was deliberately modeled on. And so administrative adjudication becomes an open avenue for evasion of the Bill of Rights on procedural matters. The standard justification is that procedural rights apply centrally to what the government does in courts, not entirely to what the government does in administrative areas. In fact, it's only through the generosity of the courts that we get some little protection in administrative matters. Hence the famous perversion of due process, that administrative agencies provide all the process that is due. Isn't that funny? But the history shows that procedural rights developed primarily to bar prerogative or administrative proceedings. Not on the side, it was the main focus. Not merely to regulate what the government does in the regular courts of law. The principle of due process of law, as I already suggested, develops as early as the 14th century in statutes, which attempt to prevent the exercise of judicial power by the King's Council. It's not about the law courts primarily. It's about what happens outside the courts. Englishmen developed due process into a constitutional principle in the 17th century in opposition, again, to the prerogative courts. It therefore is clear that the due process of law essentially barred extra-legal adjudications, not merely wayward adjudications in court. Similarly, just take another example of these procedural rights, the right to a jury develops primarily in opposition to prerogative or administrative proceedings, not merely as to court proceedings. One of the problems with prerogative adjudication in the 17th century is that it denies defendants their right to a jury, right? That's one of the complaints about it. Early Americans understand this danger of administrative proceedings, and indeed some of the very earliest constitutional cases in the United States are on the subject. In New Jersey in 1780, in New Hampshire in 1785, the regular law courts hold administrative proceedings before justices of the peace unconstitutional, precisely because they do not offer juries. The denial of a jury, like due process, is all about administrative matters, although it also includes what happens in courts. The dark history thus powerfully illuminates the constitutional problems. It shows that the Constitution barred any delegation of legislative power and that the Constitution guaranteed due process and jury rights, most basically to bar administrative adjudication. And again, there are many other examples. You can read about them if you wish, but these, I think, should show the central force of the historical analysis. Now, in conclusion, the sunny, conventional vision of the history is utterly mistaken. It misses the entire pre-constitutional history. It misses the danger of extralegal, superlegal, and consolidated power. It misses the recurring and dangerous character of absolute power. It misses how courts, constitutions, including the U.S. Constitution, systematically barred absolute power, whether prerogative or administrative, absolute power was forbidden. If we are to understand administrative power, we need an accurate history of it, an accurate conceptualization of it, and an accurate vocabulary. The first step is historical. We need to recognize the place of administrative power in the long history of absolute power. On this basis, we can begin to see the danger and can begin to respond. Absolute power was the danger that led to the development of constitutional law. We therefore can see how the Constitution barred this threat and how it is unconstitutional. The second step is conceptual. We need to recognize administrative power as extralegal, superlegal, and consolidated. On this foundation, it becomes apparent that administrative power is utterly incompatible with constitutionalism and with the ideal of rule through and under law, not the vague general notion of rule of law, but the core common law ideal of rule through and under law. And the third and final step in this reconceptualization is to change one's vocabulary. Administrative power has thrived in America because its proponents used the vocabulary of law to legitimize an extralegal enterprise. Therefore, to recognize the realities of administrative law, one must take back the language of law. One must reject the current legitimizing vocabulary and use more accurate words which acknowledge the grim realities. Administrative power seems lawful when you speak, for example, of administrative law. Even I've been doing that, right? We speak about administrative courts, or administrative law judges, or administrative due process. To be accurate, we have to speak more clearly, not about administrative law, but about absolute power, including extralegal and superlegal power. Not about administrative courts and judges, but about executive officers straying outside their constitutional authority. And we cannot talk about the process that is due, or due process in administrative circumstances, but about the administrative denial of due process. Only if we're honest in our very words can we begin to address the danger. So at stake here is nothing less than the 1,000-year common law effort to establish governance through and under law. In a brief century, administrative powers revived absolutism. It has restored governance outside and above the law. This gets justified as a modern pragmatic response to modernity, but in fact it is the recurring danger of absolutism, of extralegal, superlegal, and consolidated power. Thank you.
We have time for questions, and we do have a couple of microphones, so people online hear that. If you would wait for one. So, yes, sir.
Thank you. I'll stand up. I'm just wondering if the delegation of the congressional delegation of rulemaking or legislative powers to the states is as problematic as the delegation of rulemaking power to federal bureaucracies, and if not, whence the asymmetry? Thanks.
So the states add a very interesting element to this. There is a real risk that from the administrative perspective, any body that has more than one person is a potential administrative agency, right? So you can look at a state, a private university, a church, they all become administrative agencies to carry out federal will. How this is done is often actually quite complicated. I don't think it's been sufficiently studied. Academics, I don't think, have paid much attention to it at all. And it's a very serious problem. It just adds an extra layer because it's also destroying two extra layers. One, destroying federalism, and second, destroying the distinction between public and private life. And in the universities, of course, we face this every day. So yes, it's a profound problem. In some ways, even more so. Yes? No.
It seems to me there may be some complications in this area that I wonder if you could speak to. For example, the Congress, in enacting the Administrative Procedure Act of 1946, and that apparatus appears to have given a fig leaf so that agencies can act under color of law, and the judiciary in creating the Administrative Conference of the United States and building a legal infrastructure around administrative practices there would seem to lend some of its authority. I wonder if you could speak to that.
Yes, here it gets really quite depressing, doesn't it? Now, it's nothing new that a legislature will delegate legislative authority, but this is exactly what the Constitution prevented. The APA uses all sorts of fine language that is designed to legitimize this enterprise. But when you examine it closely, as I'm sure you have, it all dissolves into mush, right? And some of the language is really quite humorous. So for example, the substantial evidence requirement, that's the standard of review traditionally for reviewing jury decisions. Since when was HHS a jury? This is very odd. Juries are not meant to be government officials issuing commands and then deciding and so forth. So yes, the APA is at best a fig leaf. It's not even a very good fig leaf. It's a rather dry, desiccated one, isn't it? Now, your other question, remind me, was about... Yes, the Administrative Conference I find particularly depressing because, of course, what on earth is the judiciary doing? The judges have an office of independent judgment. That is the foundation of all their authority. And it's tempered only by the qualification they must decide in accord with the law of the land in cases. So what are they doing becoming, as it were, advisors to Congress in adopting? I thought this looks like a set of advisory opinions. And all sorts of judges who really should know better have been involved with this, right? This is very, very disturbing. Oddly enough, but perhaps not a coincidence. This is exactly what James I tried to do. He understood that if the judges were not, he wanted the judges not to be hard on him, he had to get them involved with the administrative or prerogative process. So he tried to get them to issue advisory opinions. And this is what led to all the early constitutional law against advisory opinions, because the judges backed off and said, we can't do this. This is the formation of modern constitutional law. But the judges seem to have forgotten this. So it's very problematic. And I think it gets even worse, because if you think about the whole process of judicial review of administrative acts, I don't want to go into a lot of technical detail now, but it's devised in a way that actually brings the judges into the process, so they feel themselves to be actually just further administrative, sort of supervisors of the administrative process and responsible for making it work. And they even say this in their cases, at which point the entire judiciary has been corrupted. So part of what needs to be done, sadly, is to educate the judges as to the very nature of their office and how they've abandoned it. Something very sobering is happening. Thank you.
Thank you very much for your lecture. I'm Brittany Corona. I'm over at the Heritage Foundation across the street. I actually found the most interesting thing you said was that the absolute power of the administrative state that we're dealing with is not so much a product of modernity, it's a product of human nature. And kind of hearkening back to Federalist 49, when Madison argues that we need to have a public sentiment, revere rule of law. And I think that your three charges, history, the conceptual understanding of administrative state, and change of vocabulary, those are all educational based. Can you kind of elaborate, how do we restore public sentiment to appreciating rule of law? It seems to be the biggest first step into regaining self-sovereignty.
Thank you, good question. And allow a friendly amendment, if I will, and then I'll get to the main body of the question. The friendly amendment is this. One of the conceptual suggestions I make in the book, and I think is actually very important, is we actually have to drop the phrase rule of law. This may seem odd, but the phrase the rule of law is not the historic phrase in common law countries. It's actually the language traditionally used in Prussia and in Germany. But yes, isn't that astonishing? Why would this be? See, the standard Anglo-American approach is rule through and under law, which means you can only bind people through an act of a legislature and through a decision of a court. But the Prussians, even the most liberal of Prussians, and many of them were very liberal and sought to have a free society, they lived in a society where these traditions had been eradicated long before. And that's actually a very interesting, sad history. And so the best they could hope for was an absolute power that was bureaucratized, regularized, and made to look like law. They called that the Rechtsstaat. And the notion of rule of law echoes the notion of a Rechtsstaat. So, for example, one of the standard defenses of administrative law is that it's in accord with the rule of law, because this power comes under the authority of statutes. And it doesn't involve that much discretion, because there are all sorts of rules and regulations that administrators work through. So I think we have to be careful with the language. Even something as revered as rule of law may not be quite the right language. I think rule through and under law actually hits home better. Now, to the superb question. How does one do all of this? What do we make of it? Well, it does seem to me the most important thing actually is not litigation, not going out and make a big fuss about this, but rather a sort of education, but an education of the spirit, not just the formal education universities, anything but that, perhaps. How is this done these days? Well, videos. Just let me take an example. Obamacare has been very illuminating, right? It's been an opportunity for people to feel administrative law. So what is a waiver? What is a waiver that deprives you of the health care that you thought you had under a statute? That's an old dispensation. We've even had some acts of suspension. People forget this language. It's worth remembering what it is, and that this is absolute power. I think these issues actually are not technical, and the danger is we make them very technical, complicated, and people turn off. But there is at the heart of the matter something very basic as to what is the mechanism that constrains you. Is it a law made by your representatives? Or is it a command, an executive command in an elective monarchy? This is not difficult. This is actually very straightforward. What is it that binds you? Is it a little proceeding in front of an administrative agency? Or is it in a court of law? So I think there are opportunities here just for education in the broad-minded sense. And after that, everything will follow. Thank you. Yes.
Okay. Aren't the principles you're articulating here all at least implicit, if not quite explicit, in the particulars of the Declaration of Independence? And so wouldn't that be a good way of infusing spiritedness in Americans today, as the document at least used to do?
Thank you. I think in general terms, yes. And the history of American resistance to the British is filled with discussions of absolute power. And many historians, academic historians, looking at this say, oh, they're just using words absolute and star chamber and big words. That's just trying to ratchet up the rhetoric. This is just ideological. But in fact, they were dealing with some of the same issues as in the 17th century, right? If you think about the use of admiralty courts to decide common law questions, it was an attempt to get a civil law court to decide common law questions without juries. And so this was aptly viewed as a problem of administrative power, of absolute power. And so the resistance to Britain and the Declaration of Independence does capture, indeed, much of the spirit. What worries me, of course, is that the spirit of independence is not quite as pervasive, I think, as at the time. And one can see that, sadly, I think, in our universities as much as anywhere else. But I don't think we disagree on that.
Your remarks seem to have very significant implications for the structure of government. If you look at the administrative law growth that we have, its rationale has been because of the greater complexity of our lives and the interactions between more and more people. So we have a large geographic country with a lot of people in it. It seems to me that the actual practice of what you are suggesting would require a devolution of political power down to smaller and smaller entities. We push problems down, but they can be solved at the lowest possible level. Would you agree with that, or do you think there are implications? Do you think this is actually doable in large democracies like we have?
So there's a lot in this question. And we might just go to your last words. Is this doable in democracies? Maybe democracy doesn't work. But of course, I wouldn't use the word democracy. And democratization of a republic is, I think, part of the danger here. The progressives simultaneously talked in populist terms and sought to remove power to an elite. And so it seems to me democratization, the notion of democratization carries some questions with it. Does devolution follow? I'm not sure. I think there's good reason to desire that we stick to our federal system. But I think that's a separate question. It's not what this is about. So this question of administrative power is mirrored at the state level, and it does involve, as we discussed earlier, some questions of federalism. But this particular critique in my book does not attack the growth of federal power, per se. It's just about how it's done. So there is another interesting question there, and I don't know whether we disagree or agree on that, but it's just not what this project is about. Is this doable, which really is the grand objection? You know, is it necessary, as the advocates of administrative law would say? I think increasingly, as administrative power expands and the level of regulation becomes more detailed and cloying, the answer is maybe it's necessary to get rid of this. You know, the reality is, it said this follows from the living constitution and of evolution, but let's face it, the living constitution is a very indefinite thing. It doesn't dictate any particular result. And why does it entrench a system of government that's developed in the Middle Ages in the 16th, 17th centuries, or even one from the 1880s, or even the 1930s? The idea that we have a constitution that's flexible but doesn't move seems rather odd. So it doesn't seem to me constitutional law doesn't stand in the way. In fact, it may require the opposite. Let's take one example. I know this is a big question, but take one example. I know a little bit about FDA regulation, because this is an example of something, the regulation of drugs and devices is something that everyone's concerned about. Perhaps we'll get hurt by what new science has to bring to bear in our lives. Of course, If you're in this field, you'll know that what will lengthen our lives is not healthcare. Nor more spending. What will lengthen our lives is the freedom of scientific development. And this is being crushed by the government in all sorts of ways. And what are the incentives for the FDA to allow science to develop? Well, on the whole, they have a predisposition to say no, not to say yes. They stand in, if they have a choice, if they have any uncertainty about the risk of a drug, they will more likely say, we will not allow development, we will not allow this to go to market, then they will say, oh, take a roll, let's see what happens. And one of the results is that there are entire fields in which we now do not have enough scientific development. Finally, people are beginning to pay attention to antibiotics. Antibiotics are now being developed, I think, by only 4 companies because no one can handle the bureaucratic morass. So FDA regulation is not going to save our lives. It will probably kill a large number of us, maybe hundreds of thousands of us. And when that happens, maybe there'll be a chance to reconsider the FDA. Not that I'm looking forward to it.
Yeah. The last question, I guess, is this. Your talk is profound. I think your historical analysis is really very enlightening. My question to you is, how do your colleagues respond to the audacity of your argument, which is nothing short of absolutely revolutionary?
Thank you. That's very kind of you. I suppose a brief answer can be summed up in the words of one colleague, a very distinguished scholar of administrative law, and he actually sent this to me in an email. It wasn't just orally. He said, this is interesting, but it's too painful to read. Go figure. But seriously, I'm very confident of the history. I've spent my life studying this history, and from manuscript sources, not just printed sources. And it's my hope, maybe it's a vain hope, it's my hope that actually looking at administrative law of the 20th century can actually illuminate one's study of the 16th and 17th centuries, and even the 14th century. This sounds odd. One doesn't read history backwards. That's said to be a Whig fallacy. But actually, if one makes the mistake of seeing one-off events and treating them as sui generis, one misses a lot. If one sees instead a recurring pattern, one then gains insights into the nature of what one's looking at, not just currently, but as in the past. And then one gets back to the very profound questions about human nature. So thank you. Yes, the history actually really does matter here in ways that we're apt to forget. If you forget the history, everything you do is novel, brilliant, necessary. If you don't look at the history. If you do look at the history, one may act with more modesty. Thank you.
Thank you, Professor. Ken reminded me that we can always make appeal to the Declaration for making good arguments. Not only does it object to the king refusing to assent to laws for the common good, but what he does do, always one of my favorite lines from the Declaration, he's erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. If that's not the administrative state, I don't know what is. Professor Hamburger's book is Administrative Law Unlawful, due out in a matter of weeks from University of Chicago Press. I highly recommend it. And lastly, I will note that our next lecture will be on June 19th. Dr. David Forte of Cleveland Marshall School of Law will be speaking on self-government for the self-governed, the role of virtue in a democratic republic. Again, thank you, Professor, and thank you all for coming.